I'm Katie Friedman, and I am the founder of Flexible Working People. And I'm really thrilled to be joined here today by Belinda Lester, who is the Managing Director and founder of Lionshead Law. Hi, Belinda.
Hi, Katie. Great to be here.
How are you?
Yeah, I'm good, thank you. Looking forward to this.
Good. So I think I'll start just by introducing Belinda, as we're really excited about this new partnership, both with her as an employment law expert and with Lionshead Law as a firm. So Belinda's recently joined us as our Flexible Working People employment law expert. And Lionshead Law is a boutique virtual firm that specialises not just in employment, but also in immigration, intellectual property and commercial law, just to give you a bit of background to the firm itself. Belinda is a really well-known specialist. She's been a trusted member of our Flexible Working People community for many years, and in an informal capacity, you've been supporting lots of our individuals and firms who are part of our community. Belinda's got a real vision and passion for a fair, inclusive workplace, which is why it fits and aligns so nicely with what we do. So I'm really excited about this partnership. So I just wanted to introduce her and the firm more broadly before we got into the details of the live today. So Belinda and the team at Lionshead Law more generally are going to support not just the community in terms of the individuals, but also companies and employers as well, as she works with both individuals and firms on their employment law issues and their rights relating to flexible working, requests, redundancies, issues around discrimination, disability, race, religion, and all those sort of issues around employment law. So welcome, Belinda. We are really thrilled to have you on board and really excited about this partnership. So let's talk about today, because today is our first of many events that we're going to be running together over the year and the coming years, I hope. And today we're going to be talking about the new day one right, the legislation around the day one right to request flexible working. There's been a lot of anticipation and optimism around this new legislation and the potential impact that it's going to have, both from an individual's perspective about what it will mean for them and the impact it will have, and also companies who are thinking about what does it mean for them, trying to understand and get their heads around the impact that it might have on them and their flexible working policies and how they might think about preparing for it. So we thought that this would be a really great topic to kick off. And I know Belinda's got lots of insights and personal thoughts around this, which she's going to share with you today. So let's kick off, Belinda, I think. Why don't we just start by explaining kind of what the new legislation is at a high level and how it differs from what we have now? I think that would be really helpful as a start point.
Sure. Thanks, Katie. Very, very quickly, before I go into that, I just want to say that flexible working, a lot of people, a lot of employers, when they think of flexible working, they think, it's home working post-COVID. Everybody now just wants to be at home. And there's an awful lot of a sort of misconception that flexible working is one thing, when actually flexible working is what it says on the tin. It's flexible. It's anything that is outside the standard working arrangements that go on in that business, which used to be the 9 to 5 in an office, but full-time. Part-time working is flexible working, home work is flexible working, hybrid working is flexible working, job share working is flexible working. There are as many types of working as there are people, probably. So that is what flexible is. So I just wanted to sort of say that at the outset, because we're not just talking about the things that have happened. Although COVID, I think, perhaps brought this forward more quickly with people working remotely. That's not what flexible working is on its own. So at the moment, an employee needs to have worked for their employer for 26 weeks before they can make a request for flexible working. Under the new legislation, which is due to come in force in spring of next year, it will be a day one right. So for the minute you start working, you can make a flexible working request. At the moment, the onus is on the employee to consider what impact their request could have on the employer, rather than and to try and come up with solutions. Under the new legislation, the employer really has the obligation to consider the request and think about it and think about how they can make it work. It is not the employee's job to put forward solutions. At the moment, you can make one request a year. The idea is that you can make 2 a year. And currently an employer responds within 3 months. Under the new legislation, they have to respond within 2. And currently there's no obligation on the employer to consult, but under the new legislation, the employer will have to consult before reaching a decision. So that's the headline summary of the new legislation.
Okay, thank you. So I think for the rest of this session, we're going to unpack that a bit more and get into a bit more detail about what that actually means. So we've been talking about this for a long time, and I think that the last time I updated on this, we said that it just gone through its 3rd reading at the House of Lords, and it requires royal assent before it becomes law. When do the changes actually come in? Because I feel like this has been sort of really long time talked about, and we're not really clear on that. You just said spring. Is that
it's certainly going to be probably 1st of April?
Okay, yeah. And is that's
normally the date that these things, once they go through the process, they get implemented. Normally, I'm anticipating the 1st of April.
Okay, so spring next year. Okay, so let's just talk about this day one right. What does that mean, day one right?
Well, it's really interesting because when the fanfare first, came about these changes, and everybody was saying it's a seismic shift and this is going to really improve things. And my first thought was, is it really? Is it really going to be substantially different from how it is now? Because, of course, the right is to request flexible working. It's not the right to be granted flexible working. And so my initial feelings about it were, is this really so fantastic? But thinking about it more, and particularly the day one right, I think this is going to be fundamental. Because if there's a day one right, I think employers are, in practical terms, going to have to think about all their jobs when they're advertising them. To think practically, is this a role that can be done flexibly? Because the reality is, when I offer the job to somebody and they accept it, they could turn up on that first Monday and make a flexible working request. Do we really want to have to deal with a flexible working request with a new starter when we could have dealt with this at the interview stage? And so I think that whilst initially I was like, so on reflection, I think it's a really important thing for employers to consider. And they need, because I think the best employers are going to be considering it at the point of advertising. And I think it is this which could potentially lead to companies really thinking about every role, can it be done flexibly?
Exactly.
So the advert. So that, I think, is the key, and is the day one right that is going to have to be implemented by secondary legislation. But I think it will be, and I think the plan is for both pieces of legislation to take effect on the same day.
So that's really interesting that you've said that. And actually, I had exactly the same reaction to you. So initially it was like, oh, on the fanfare, this is amazing. And then I took a step back and I've really considered it. And then I thought about the day one right. And I was like, I don't really understand that, because if you get a job and you've been through an entire interview process, are you really going to turn up having not discussed flexible working with a potential new employer until you arrive at work on your first day and then say, I know that we've never discussed this before, but here's my flexible working request. So actually the impact could and probably will be much bigger, because employers are going to be forced to think about that before. And also, as you know, in our community, people are asking, well, they ask all the time, at what point should I bring up flexible working? It's always been that sort of taboo, should I bring it up? But this is going to open up the floodgates again to say, well, actually, you've got a day one right to ask. So you should be bringing this up way before you start your new job.
Actually, weirdly, I think interviewees will still be reluctant to bring it up in interview, because they know that they can turn up on day one and have some protection. Because if they make the flexible working request and even if it's turned down and the employer's gone through the whole process fairly, if they then terminate that employer's employment, even in the first 2 years, the employee could potentially say, you've sacked me because I asserted my statutory right to request flexible working. Right. So there is a risk to employers of waiting till day one. Because even if they wait till day one, because the person hasn't actually raised it in the interview, they could find themselves in a position where they've got somebody who isn't possibly working out, but that person thinks, well, the reason they think I'm not working out is because I made a flexible working request, and I want.
And so there could potentially be.
And so there's a potential for automatic unfair dismissal claim, even very, very early on. So I do think there's going to be an awful lot of people finding their feet here as this legislation beds in. And I will be advising my employer clients to really, really think about all of this at the job advertising stage, rather than waiting for the interview. So, as I say, although initially I was a bit sort of like damp squib about it, the more I think about it, the more I think that actually by the back door, this could bring in the all jobs should be flexible unless otherwise stated. It might actually,
which was where we wanted this to land in the first place. Exactly. That's so interesting. That's so interesting. Thank you for that. And I think that the companies are, that's real food for thought for them to now be starting to think about this, and what the impacts that not thinking about this earlier on in the process might have on them in the longer term. So thank you. Okay, so back to the request. So do you think that between now and spring, as this is coming, employees might be able to ask their employers if they can honour these new provisions before they come law? Like, how likely do you think that is? Now it's coming down the line. Do you think that it's opening that up now for?
I see no reason at all why employees shouldn't make flexible working requests at any time. And I have to be honest with you, even when it was a 26-week thing, why not ask?
Yeah.
The statutory right to make the request kicked in after 26 weeks, but an employee has a right to make requests about things at any time about anything.
So absolutely, yes.
So absolutely. And the reality is that, employers might initially think, well, hang on a minute, we don't have to do this until next spring. But but practically it would be really good practice, I think, for employers to start thinking about how they might operate after next spring. And I think if any employee starts to make use of this now, I think it would be very good for employers to bear the new legislation in mind. The time will go very quickly.
Absolutely. Okay, so let's talk now about the shift from the onus being on the employee to prove that flexible working will work, which has always been a tricky thing to prove from an employee point of view. And the onus has always been on them up until now. And now it's shifting to the employer who must prove that it won't work. So I'm just interested in your take in what this change actually means in terms of employers having to turn down requests, and what will the criteria be? Has that changed, or is that the same?
No, the criteria,
what does that look like in practical terms?
The same, and I'm not sure that it's actually quite right that the employer that the burden is on the employer to prove that it won't work. I think the burden always was on the employer, really, to come up with the reasons to why it might not work, and the burden on the employee is to anticipate what problems there might be and how they could be overcome. I think there are two reasons why this has been put in to the legislation. I think it's practically, again, what it is trying to do sneakily by the back door, and possibly from political reasons. Let's not forget we're talking about politics here, not just law. How do we give everybody, the employees, this notion that all jobs should be advertised as flexible without scaring off employers that they've got to advertise all jobs as flexible? So what this does is, again, because it's a day one right, in effect, it does make employers have to think about every job. Is this a job that can be done other than on our usual Monday to Friday, 9 to 5 in an office, without having to wait for an employee to come and make a request. So although the reasons for turning it down haven't changed, what it does again is, along with the day one right, the two of these things together, I think, nudge employers into thinking, how do we look at all our roles in the company, and do we actually now go through them all and work out whether any of these can't be done flexibly, and if not, why not? And from the very, very beginning, address those issues. And I think that is what is going to, hopefully, fingers crossed, that is what's going to start happening. And that's not to say that there won't be any jobs that can't be advertised as inflexible. And as obviously, the bigger you are as an organization and the more resources you have as an organization, the easier it is probably going to be to accommodate. Small businesses, small employers who are absolutely terrified about this, I think a lot of them, are still going to have, a defense. They're still going to be able to say, well, we'd love to be able to do this, but we simply don't have the resources or the financial backing to be able to implement these things.
Yeah. Okay, so you've talked quite a lot. My next question was going to be around what employers need to do to prepare for this change. And you've talked quite a lot about thinking about job design, which I think is really important, and thinking about, before you even get to the interview stage, thinking about the job and whether it can be done flexibly from a legal point of view or from a planning point of view in terms of preparing for this new legislation regarding maybe their flexible working policies and, how this is managed. Is there anything else that, employers need to think about before the day one right comes in spring?
Absolutely. I mean, to be honest, it's something that they should have always been thinking about. And it's the thing that most companies, and in fact, most HR professionals, not all, but an awful lot of HR professionals who deal with flexible working requests totally forget about the discrimination legislation. And whilst there are a number of reasons that an employer can turn down a flexible working request, that's not the end of the story. Because at the moment, I'm hoping it will change. I'm really hoping it will change. But I think we've got a long way to go. But at the moment, the vast majority of people who make flexible working requests are women. And the reason why the vast majority of those requests are made by women is because, whether we like it or not, women are still the primary caregivers of children and the primary caregivers of elderly parents, primary caregivers in society as a whole still. And until that changes, what it means is that full-time office-based working is what's called a provision, criterion, or practice, which has an indirectly discriminatory effect on women, because fewer women than men can comply with it. And in order to, you are allowed to indirectly discriminate as long as you can show that it's what's called a proportionate means of achieving a legitimate aim. So you have to have a legitimate aim. Well, the legitimate aim is the 10 points why we're refusing, one of those things. That's our legitimate aim. The thing that most employers forget is it proportionate? Is the impact on us going to be so much greater than the impact on that employee if we turn down the request?
Yeah. So you're saying that they're opening themselves up to discrimination claims over and above. They need to think more widely than just offering flexible working or not. Yes.
Exactly.
Really interesting. Okay, we're really getting into the nitty-gritty here, and it's great. And I think people are going to really benefit from this. Okay, so we're flipping a bit from employers to employees, but I think that's good because it affects both. And actually, that's what we wanted this to do. So I'm just going to flip back to the employees, the individual for a minute, just to ask you, now that the onus is not on them, do you still think that there is a benefit for them to be thinking about, offering solutions for why it might work? Or has the onus shifted completely? Is there still a benefit to doing that? And do you think it's a good or bad idea for them to give reasons for why they might want to work flexibly, or they just don't have to and therefore don't? It'd be great to get your insights around that.
So for the reasons that I've just given about the indirect sex discrimination, I think for women who are requesting flexible working because they're carers, I think it's a very good idea to say so.
That's interesting.
I really do. You don't have to, but it's your personal choice, because anybody can make a flexible working request for any reason. But the reality is that if you are making this request as a woman because of this reason, and because the impact of the refusal on you is effectively that you probably can't actually do the job.
And therefore, you are actually protecting yourself longer term with a potential discrimination claim.
Potentially
That's
bring
so
a
interesting
discrimination claim, right? So I'm not saying I don't encourage people to approach their employers with litigation in mind. I really don't. You know, but I also think that when I advise employers, I give them advice that I think will best protect them, put them in the strongest possible position. And similarly with employees, you know, if you are in a position where you're trying to, you know, you've got a good relationship with your employer, and I don't think people should be trying to be confrontational or trying to, you know, get one over on their employer or anything like that. But the reality of life is we should act as if things are going to go well, but prepare in case things don't.
Yes.
And, you know, it's not, I don't think it's going to do you any harm to give a reason. Similarly, I don't think it's going to do you any harm at all to help your employer.
I agree.
Bring about what you want.
And understanding the reasons is also a great reason why to want. Yeah.
As is understanding where the roadblocks might be, because I think the employee is best placed to address that, to be honest, and to help come up with those solutions. But as I say, on a case-by-case basis, and it's not something I say you should always do or you should never do, but I wouldn't discount it.
Okay, really useful. Right, so another thing that you just said, which is really interesting and an area that I just want to explore with you a bit more, is around women being the predominant caregivers and the majority of flexible working requests coming from women, which is absolutely right. And the data shows all of that. And we're still not in a place where, you know, we're in a place of equality where men and women both require, although things have shifted since COVID, it's definitely not where we want it to be. So I suppose my question is, do you think that the legislation changing and making it this day one right to request might encourage more people, or specifically more men, to apply to work flexibly? Do you think there will be an impact on that or not?
So it worries me. I'm not going to pretend. That it doesn't worry me that, as very often happens when legislation is brought in that really is there primarily to benefit women, unfortunately, what that often ends up doing is disadvantaging women in the workplace, because any legislation that just is really for the benefit of women, or that it's the benefit of everybody, but actually it's mostly women who utilize it, it just makes women more difficult to employ. It just reinforces to employers how difficult women are. And so my concern about this is that whilst it's a day one right for everyone, unless jobs are actively advertised as flexible, and unless employers really buy into it, it is really still going to be women who want it. And in an interview, when you're interviewing these women, not only might they get pregnant, not only might they take maternity leave, not only might they get menopause, but now they're going to absolutely want to, on day one, request flexible working. Is this potentially going to make things harder rather than easier for women? I hope not. I really hope not, because I do think, and I'm cautiously optimistic that more men will feel empowered to request flexible working. I think COVID has really done a lot to promote that and to promote the desire for it. But there is some evidence that the men are going back to work, going back to the office. I think time will tell. I could go on for hours, days, weeks, months, years about what legislation I think should be in place. So this is probably not the time to talk about it. But I think we do need to bear. I think people need to bear this in mind, and I think from a purely practical point of view, if we can encourage men to make full use of this legislation, it will benefit everybody.
I agree. And I know that a mantra that you talk about a lot, and I fully agree with, is that equality starts in the home and that legislation only goes so far. But if you want equality, it has to start at home. And I think that, in many cases it doesn't. There's
division of labour. Women don't have it all, they do it all.
Yeah. And it has to change and that will have the biggest impact on the workplace if it starts there. Okay, well, this has been really insightful. I've really enjoyed this, and there's been huge amounts of value that I think that both individuals and employers are going to get from listening to this. And what we'll do is we'll share this both in the group and everywhere else, because I think that there's a lot of food for thought here for employers, both in terms of what they need to think about, the impact it will have, the planning that they need to do, and some of the other nuances actually that come off as a result of this. So we started this by me saying, what do you think? And there was lots of optimism. And I'm going to conclude this by asking you, in your opinion, how do you think this will land? And do you think that this is a great step or a small step forward for flexible working?
I think it's a great step forward for flexible working. I hope it's a great step forward for women. and let's watch this space, Katie.
Okay. So we'll leave it there because we've run to time, but thank you so much. I really enjoyed that. And I think that there were a huge amount of insights there. So I hope that if you've been listening, you've garnered some really good information and you feel a bit more informed as we head towards this new legislation. So as one of our Facebook listeners said, I'm sitting here nodding to all that you're saying. So much of this absolutely starts at home. Absolutely. So thank you to Belinda. It's been great having you. We've got lots more of these sessions planned, which we'll be sharing over the coming months. You can contact Belinda directly through her LinkedIn profile. We'll share that. Also contact her through Lionshead Law, the firm. And if you're a member of the Facebook group and you're listening, then Belinda is an active member of our community and is always there. You'll find her answering questions and having an opinion on lots of things, which we love. So thank you, everybody, for listening. Thank you, Belinda, and we will see you all soon.
Thank you so much, Katie. Thank you. Bye-bye.
Bye.